Good morning, ladies and gentlemen. It's my great pleasure to welcome you to today's panel discussion on criminal procedural aspects of environmental crimes. Environmental crime represents one of the most pressing and complex challenges of our time, as legal systems across Europe strive to respond effectively. It becomes increasingly important to understand the diverse approaches taken by different countries in investigating and prosecuting such offenses. In this session, we will focus on the criminal procedural aspects of environmental crimes in the Czech Republic, in Poland, Slovakia, and Hungary. Our aim is to explore how these jurisdictions handle such cases, what legal and institutional framework are in place, and what challenges and best practices can be identified. To begin, I will deliver a 15-minute introductory presentation offering a comparative overview of the key features and differences in criminal proceedings related to environmental crimes across the 4 countries. Following this, each of our distinguished panelists will provide a 5-minute reflection in response to a set of guiding questions, drawing on their national experiences and professional expertise. Let me now introduce our panelists. Professor Dr. Marek Fryšták, full professor at the Masaryk University, a city with a focus on the procedural aspects of prosecuting environmental crimes in the Czech Republic. Dr. Burdziak, associate professor at the University of Czechia, with a focus on the procedural aspects of prosecuting environmental crimes in Poland. Mr. Marek Adamkovič from Comenius University, with a focus on the procedural aspects of prosecuting environmental crimes in Slovakia. My name is Dr. Jánosi, associate professor at the University of Miskolc, and I will deal with the Hungarian perspective. We are looking forward to a rich and engaging discussion. Thank you for your joining us today, and with that I would like to begin the session with the introductory presentation. So my assignment was to examine and synthesize the distinctive aspects and similarities of criminal procedures in the Visegrád countries with regard to environmental crimes. This presentation examines the role of criminal procedure in environmental offenses, its procedural complexity, and the governing legal framework. Drawing on the available national reports, the following principal conclusions can be outlined. All 4 countries treat criminal law as an ultima ratio instrument, emphasizing that administrative law is the primary mechanism for environmental protection. The legal framework are broadly similar, relying on a general criminal code and the code of criminal procedure. A common source of complexity is the difficulty in demarcating administrative and criminal liability, and the fragmentation of legal framework. Additional challenges include high latency, low public awareness, evidentiary difficulties, and frequent legislative changes. This presentation contains 6 comparison criteria, which are the follows: initiating criminal proceedings, investigation and evidence gathering, trial and sentencing, appeals and legal remedies, challenges and future perspectives. The first criteria was initiating criminal proceedings. This criterion examines the initiation of process authorized parties, the role of administrative bodies, and statistical data. In the Czech Republic and Slovakia, only the police and prosecutor are authorized to initiate criminal proceedings. Administrative bodies can only file reports. Hungary and Slovakia report the widest range of sources for reports. Statistically, Hungary shows the highest number of registered crimes driven by waste management offenses, while in Poland, the prosecution of collective entities is extremely rare. The new EU directive will expand the scope of criminal offenses and clarify concepts in all countries. In the Czech Republic, proceedings are initiated by the police or by the public prosecutor based on a criminal report. Administrative bodies cannot initiate criminal proceedings, but they cooperate and file reports. Related to statistics, low statistical incidence and high latency are characteristics. The most frequent offense is animal cruelty. In 2024, 48 persons were prosecuted for animal cruelty. In Poland, proceedings are initiated by the prosecutor or the aggrieved party. The Environmental Protection Inspectorate has procedural power, including prosecution. In Hungary, criminal protection is ultima ratio compared to administrative and civil law instruments. The regulatory environment is highly complex, touching upon constitutional, administrative, civil and criminal law. This complexity, along with the frequent legislative challenges, lead to demarcation problems between administrative offenses and criminal offenses, resulting in a relatively high proportion of terminated criminal proceedings. In Hungary, proceedings begin with an investigation. Any person may file a report. Reports come from a wide range of sources, for example, private individuals, national park directorates and authorities, for example, border controls, notaries, veterinarians. Administrative bodies play a role in detection and reporting. Related to statistics, approximately 2,000 investigations are ordered annually. There is an increasing trend. The most frequent offenses are violation of waste management regulations and animal cruelty. Latency is high, as is the rate of suspensions due to an unknown perpetrator. In Slovakia, proceedings are initiated by the prosecutor and the police investigator. Reports come from a wide range of sources: citizens, NGOs, nature guards, and state authorities. Proceeding can be initiated against an unknown perpetrator as well. Related to statistics, in 2024, 283 cases of unauthorized waste handling were initiated, but only 102 individuals were prosecuted. Based on convictions from 2020 and 2024, the most frequent offenses are poaching, waste handling, and animal cruelty. In all four nations, criminal proceedings are typically initiated by the police and public prosecutors. Administrative bodies such as environmental inspectorates play a crucial role in reporting crimes and cooperating with law enforcement, but they generally do not initiate criminal proceedings themselves. Statistical data reveals common challenges. High latency is a major issue in the Czech Republic, Hungary, and Slovakia. Hungary and Slovakia also reports a high number of cases terminated during the pre-trial phase, often because the act is not deemed a crime or the perpetrator cannot be identified. Across the reports, the most frequent prosecuted offenses are animal cruelty, illegal waste management, and wildlife crimes such as poaching. The second comparison criteria in investigation and evidence gathering. This criterion identifies the authorities responsible for investigation and the key types of evidence. General Police and Prosecutors' Office handle investigations in all countries. However, the level of specialization varies. Hungary and Slovakia have established specialized units. Hungary created the National Environmental Security Task Force for interagency cooperation and utilizes specialized police units, while Slovakia uses a dedicated department within its National Center for Special Types of Crime. Poland faces a unique and significant investigative hurdle. Its police are explicitly prohibited for using operational surveillance for environmental crimes. This contrasts with Hungary, which explicitly uses such covert means, and Slovakia, which uses them in organized crime context. In the Czech Republic, the Czech police acts as the general